Welcome to the Columbus Metropolitan Club. I'm Carol Looper. I'm a member of CMC's Board of Trustees. I used to be a reporter for about 37 years, and it never goes away. Very good to see you all today. Today's Columbus Metropolitan Club Forum is brought to us with support from Taft Law and the Jeffrey Company, and in partnership with the Columbus Bar Association and the Chief Justice Thomas J. Moyer Legacy Committee of the Ohio State Bar Association, each of whom have many friends and associates in the audience. Please help me thank them. And now welcome David Butler, partner in charge at Taft Law, to the stage, and he will introduce our forum. David. And I am going down the steps.
Thank you, Carol. I'm Dave Butler, as Carol said, the partner in charge of the Columbus office of the Taft Law Firm. It is a pleasure for us to sponsor today's program. We'd obviously like to thank the Columbus Metropolitan Club for everything that it does with these wonderful luncheons and the public discussion. It's always topical, it's always relevant, and we always have an all-star cast of speakers. Today is absolutely no exception. We look forward to the discussion from our speakers today with really a neat discussion that is really topical with constitutional law. Obviously, we've seen the headlines recently where constitutional law has been front and center, and really do a deep dive here on both the federalism and the federal constitution and how it interplays with the state and the state constitution. And we have two distinguished, couldn't be more distinguished jurists here, both from our federal system and our state system. So look forward to today's event. As far as introductions, CMC in its infinite wisdom has given the extended bio for everybody on the handout here, so I'm going to cut right to the chase. Our first speaker is a Justice of the Ohio Supreme Court, Justice Judy French. Obviously, the Ohio Supreme Court is the highest court in the state of Ohio, and I'm sure Justice French is very happily here spending time with us today at lunch rather than on the campaign trail for next week's election. So thank you very much for being here. And we also have Judge Jeffrey Sutton, from the United States Court of Appeals for the Sixth Circuit, which obviously entails Ohio and 3 other states, and is the appeals court in our federal system. And look forward to a wonderful, wonderful discussion. And Jeff, please, one of our colleagues at Taft, I must take a moment, just joined Jeff at the Sixth Circuit Court of Appeals, our partner down in our Cincinnati office, John Nalbandian. So, Jeff, you're taking my appeals guy from me, and I got to find someone else to handle my appeals. So anyway, with that, I toss it over to the justice. Thank you.
Well, I thought I would make a couple opening remarks. So first of all, thank you to the Metropolitan Club, to the sponsors. When you write a book, you learn who your friends are. So thanks for supporting me and give me a chance to talk about this a little bit. So I was just going to chat for a little before my good friend Judy and I discuss some of the topics in the book and try to relate them to what's going on in American legal culture. So I'm coming out of church a couple months ago, and a friend of mine that many of you know, Dr. Richard Briggs, he's a retired doctor, comes up to me quite enthusiastically and says, Jeff, I hear you've written a book that's so exciting. Is it an autobiography? I said, no, it's not an autobiography. Well, is it a mystery? No, not exactly. Well, Jeff, what's it about? And then with lots of enthusiasm, I said, state constitutions. Long, awkward pause. And Dick said, you sure it's not a mystery? And, well, Dick Briggs was actually right. Dr. Briggs was actually right. There's part autobiography and part mystery, and I thought I'd start with the autobiography, which is why did I do this? And then I think some of the rest of this will come through in the conversation. You know, if you look at books about constitutional law, if you think about your 7th grade civics class, high school political science class, or government class, we really focus on our constitutional law stories on the U.S. Constitution and the U.S. Supreme Court. In fact, I would go so far as to say we are obsessed with the U.S. Supreme Court. That set of stories, that narrative, is perhaps best illustrated by the end of a terrible chapter in American history, Jim Crow. And U.S. Supreme Court correctly deserves credit for ending that awful chapter in our history with Brown versus Board of Education, a 9-0 decision that ends racial segregation. And we correctly take great pride in that story, as we should. And I think it's a positive story in America. What I wanted to set out to do was not contradict that story. I actually want to keep it where it is, high on the podium. But I did want to supplement that story with some stories in which the state courts, state legislatures, and state constitutions deserve a starring role, where they really made a difference, they really protected our rights in ways we care deeply about. And actually a couple stories where the GOAT, the villain, was the U.S. Supreme Court, who dropped the ball by the verdict of history. So that's explanation number one for this project. Explanation number two is also autobiographical, and it relates to my experience the last almost 16 years as a federal judge. I'm quite nervous about the path the federal courts are on, and I'm quite nervous especially about the path the U.S. Supreme Court is on. During my legal career, I graduated from law school in about 1990. This is what I have observed when it comes to constitutional rights and disputes at the U.S. Supreme Court. I see a blue right being created, a red right being created, and rights escalation up, 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 up. You get your rights, we get our rights. If you can't beat them, join them. Now, this is an understandable approach to the Constitution and the U.S. Supreme Court. Who wouldn't want a winner-take-all victory at the U.S. Supreme Court with a constitutional decision? It really doesn't get any better than that as a matter of power. You get a national decision that recognizes your right. And if it's a constitutional decision, it means you've sidelined your opponent. They're not even allowed to go to the ballot box, whether at the state level or the federal level. So it really doesn't get any better than that. So you can understand why we all want that. In fact, I really don't blame the U.S. Supreme Court for this rights escalation. I blame us. We want it. We keep going back to them. We support interest groups that support these winner-take-all fights. So they're going to continue. That is the path A we are on. In one sense, as a federal judge, I shouldn't mind Path A. It makes my job description look better. If you're an investment manager, more money is better for you. If you're a judge, more power, better for you. It makes my job more interesting, I suppose. It puts me in charge of more significant policy calls through the U.S. Constitution. There's just one problem. While the American people may be foolish in the short term, they're not foolish in the long term. And the American people have gradually realized how much power this court is exercising in blue directions and red directions. They now care deeply about controlling that court. So unless you've been under a rock for the last several years, you have noticed some very intense fights about how we fill vacancies on that court. In fact, I would go so far as to say that the last presidential election 2 years ago turned on treating the presidential election as a proxy to fill one slot on a 9-member court. That is an astonishing concept. I can promise you that in 1776, during the decision to break from England, no one was saying the reason we need to do this is to put 5 members of a 9-member life-tenured court in charge of all of the key issues in American government. That was not why we broke from England. So something has changed dramatically in American history, and I think what's really happened is it's been an increase in the power the U.S. Supreme Court has had over our lives. Now, it's great when you win. It's just not that much fun when you lose. How do we get off that path? Well, ideally, we would have a détente, which is to say fewer national winner-take-all rights disputes resolved at the U.S. Supreme Court. And the best way, it seems to me, you could have a détente is if we Americans were more willing to go to state court and rely on state constitutions as a way to protect our rights. Now, here's the slightly nerdy part of the conversation. There is not a single provision in the Bill of Rights or in the 14th Amendment that did not originate in the state constitutions. The greatest era of constitution writing, of rights creating, was between 1776 and before the fabled summer of 1787. All they did in 1787 was cut and paste from the rights that had been created from the state constitutions. So all I'm urging is for us to think a little more seriously about rights recognition, identification, and respect through state courts and state constitutions. And the last way I'll put it, and then we'll shift to the conversation, is even in this polarized age, I'm pretty confident we all agree with this wonderful insight by Justice Louis Brandeis, which is that a great virtue of federalism is that you can use the states as laboratories of policy-making experimentation. Now, what Brandeis was referring to was using state legislatures to innovate, and it makes perfect sense. Why try a novel experiment with 51 jurisdictions and 320 million people? But he's referring to state legislatures. The whole pitch of my book, the whole pitch of this argument, it's let's not just use state legislatures as a way to mediate our serious disputes about how to handle difficult social policy issues. Let's use state constitutions for the same purpose. Because every constitutional guarantee we care deeply about, equal protection, due process, free speech, I promise you, is also protected in the Ohio Constitution, indeed in all 50 constitutions. So just as we use state legislatures as labs of policymaking experimentation, we should use state courts as labs of constitutional interpretation, which will help mediate these very difficult disputes. And I think one reason we're so polarized these days is the stakes are so high when all you want are winner-take-all fights at Congress or the U.S. Supreme Court, because frankly, the stakes are high. If you're going to do a winner-take-all approach, it's actually quite rational to be as sharp-elbowed as we have been about filling vacancies in the U.S. Supreme Court or trying to win contests in Congress. So, Judy, you must disagree with something I said, or maybe even agree with part of it. Not yet. Yeah, there's time.
But
there's
I will.
time.
Jeff's book really tells stories. It tells particularly 4 different stories that arise from different areas of constitutional law. One of them is probably very familiar to this audience, and I know you had a personal role in it, and that has to do with the equality and adequacy of school funding. So you begin in the book with Brown v. Board of Education, which of course ended segregation in public schools, but maybe talk a little bit about the role that state courts played in what happened next.
Yeah, so my former boss, Attorney General Betty Montgomery is
our
here.
former
Former boss, Betty Montgomery is here, which is wonderful. Every idea in this book originated with that job, so I'm incredibly grateful to Betty for that experience. And I'm even more grateful that she kept me on, because my experience as the Ohio State Solicitor was basically that I lost one case after another in the Ohio Supreme Court under the Ohio Constitution. That's how I learned we had an Ohio Constitution, and that's when I learned how significant it could be. And thank God Betty didn't fire me, and she really should have, because no one was as bad as I was. I lost one case after another: school funding, school vouchers, tort reform, criminal procedure. But the school funding case is really a great case to illustrate what I'm talking about, and I think something Judy and I both agree about. School funding is about as essential to good policy in this country as it gets. In fact, the school funding cases are the other end of they're the bookend to Brown versus Board of Education. Brown gets rid of racial barriers to a fair and equal education. The school funding cases are about dealing with the difficulty. Okay, fine, we've gotten rid of racial barriers, but what about wealth-based barriers? What about the problem that kids in inner cities or rural Ohio public schools are not getting the same education as kids in Upper Arlington, Bexley, Shaker Heights? That's a serious problem. And so the U.S. Supreme Court had a chance to deal with that issue. It chose not to. It left it to the states. I personally think even though the stakes were as high as they were, that was a good decision, because I think it would have been very difficult for 5 members of a 9-member court to basically be a school board for 51 jurisdictions, 320 million people, and so on. Well, that shifted the litigation to the state courts, where 2/3 to 3/4 of the state courts in this country have granted victories of one sort or another to the plaintiffs in those cases. And of course, I was on the other side of those cases. So the point isn't whether they were right or wrong. What is the point is those cases illustrated that states don't always have to be distrusted when it comes to dealing with counter-majoritarian issues, minority issues, wealth issues. The state legislature in Ohio did quite a few very progressive things in trying to solve that problem. And then a few more things were done after the 4-3 school funding DeRolf decision. But to me, the point isn't whether they're right or wrong. The point is, this is a very big country, and in an area where we care so deeply and prize so much constitutional rights, we'd be very wise to localize more of these disputes rather than nationalize them. I mean, that's the point of the title. You're dealing only with imperfect solutions when you're dealing with school funding. There is no perfect solution. If there were, we would have figured it out long ago. So in a world with lots of imperfect solutions, why? Why would you want just one imperfect solution? Doesn't make sense. So it's really a good area for either state courts, state legislatures, state governors to perform a role in trying to equalize, this opportunity we all have in life, which is going to get a good start if you get a good education. And ideally in education, it's not that different from the education the kids in the next school district are getting.
In DeRolf, you were facing an elected Supreme Court. Do you think that was an advantage, or was that a disadvantage?
Are they still elected on the Ohio Supreme
They
Court?
are.
Yeah,
They are.
Yeah, well, that was the other thing about this. So when I came out of law school, I thought, how can you elect judges? Why would you use a majoritarian election process to pick people for what is a non-majoritarian job? I mean, judges are not supposed to put their fingers in the wind and say, what do the people want? What's popular? It's completely the opposite. I mean, if we have a terrible capital murder case in front of us, and the Constitution means we have to let this guy out of jail or stop the execution, we're supposed to do that even if 100% of Ohioans disagree with us. So I came out of law school a little skeptical of the idea that elected judges could protect individual rights. My experience as state solicitor proved that's not accurate. They were just as willing to protect individual counter-majoritarian rights as I thought the federal courts. In fact, I actually thought I would have had a better shot at winning as state solicitor in the school funding case had I been in federal court. So to me, what happens is it's all about the good advocate and legal imagination. How do you craft an idea, an argument, to make a group of people, whether they're elected or not, think it's a good idea? So I sometimes think the fact that we have elected judges can help with rights innovation. And so I little smile there. I saw it.
Not everybody agrees.
No, well, it is very easy for me to say this. Yeah, that's true. I don't have to run for office. I am thankful for that.
Well, let's talk more about one of the other stories that you tell. Really, the one that was the most compelling for me is the story about compelled sterilization and the topic of eugenics. So for the benefit of our audience, if you want to remind them of what eugenics is and what that looked like in 20th century America.
Yeah, no, it's an astonishing chapter. I mean, I don't know if I'm going to say it's as bad as Jim Crow, but it's an astonishingly bad chapter in American history, and people have forgotten it. So I'll read from an eugenicist. I'm not reading, these are not my words. Again, these are not my words. Nearly all the happiness and nearly all the misery of the world are due not to environment but to heredity, that the differences among men are in the main due to differences in the germ cells from which they are born, that social classes, therefore, which you seek to abolish by law, are ordained by nature, that it is, in the large statistical run of things, this line really gets me, not the slums which make slum people, but slum people who make the slums. That if you want artists, poets, philosophers, skilled workmen, and great statesmen, you will have to give nature a chance to breed them. Well, that was a leading eugenicist, and the idea, this was an establishment movement that caught on in the early part of the 1900s. It was taught at Harvard, Stanford, the key elite universities in our country. It's actually a movement that did not catch on in the South. It's an East Coast, Midwest, and Western movement. And to make the eugenics movement work, you had to pass state laws, which allowed states to involuntarily sterilize the feeble-minded. This was the catchword. It covered a lot of, quote, sins from their perspective: mental disabilities, prostitution, violations of criminal laws, epileptics, unemployment. It's just an astonishing idea. And so about 15 states in this country passed those laws. The part of that story you probably dimly remember is it leads to a case called Buck versus Bell in 1927. And in an 8-1 decision written by perhaps the most well-known justice on the U.S. Supreme Court, Oliver Wendell Holmes, they uphold eugenics legislation. 8-1, the leading progressive in the country at the time. Louis Brandeis joins the decision. The leading conservative, William Howard Taft, joins the decision. Only Justice Butler dissents. He doesn't explain why, so God only knows. So that's the part of the story you know. The decision has this infamous line, 3 generations of imbeciles are enough. The underlying individual in the case, Carrie Buck, it turns out they were wrong. They whiffed all 3 times. Carrie Buck had normal IQ, had done well in school. Same was true for her mom, and same was true for her daughter. So it was just an exaggerated case. It was really a collusive case where the lawyer ostensibly representing Carrie Buck had worked on the colony, might be called an institution, before he represented Carrie Buck. In other words, he was on the board of directors of the very colony that wanted to sterilize her and then became her lawyer. Now that's not what you're looking for in great representation. And it obviously didn't work with this 8-1 decision. So it's a really unfortunate decision, which, believe it or not, has not been overruled yet, which is quite astonishing. Here's the part of that story you don't know. Before 1927, there were 8 lower court cases, 6 in the state courts. 7 of the 8 lower court cases get it right by the verdict of history. They stop the sterilizations in their path. The best decision is this wonderful decision from the New Jersey Supreme Court, which prevents Alice Smith from sharing a similar fate with Carrie Buck. And the other decisions are really to the same effect. Several of them rely on state constitutions. So that's a story that illustrates 2 things. One, if we rely exclusively on the U.S. Supreme Court to protect our rights, at some point you are going to be sorely disappointed. That's what happened in Buck versus Bell. The second thing it illustrates is don't assume state court judges, even elected state court judges, are not going to be willing to enforce their own state constitutions to protect these rights, because that's exactly what they had done before 1927. And that's the message I want us to take a little more seriously. The winner-take-all stuff at Washington is great when you win. Not so good when you lose. And if you want it, don't be surprised when your political opponents want it as well. It's going to be rights escalation. I promise you. It will continue to be rights escalation unless we're willing to mediate some of these disputes through state legislatures and state courts using state constitutions.
So what was it you called the legislatures, the heroes of that story?
Yeah, so it's Buck versus Bell. In this country, the eugenics movement lasts about 75 years. 60,000 individuals are involuntarily sterilized. Quite a few more women than men, for what it's worth. It ends not with state court decisions. Buck versus Bell became this Madison Avenue advertisement for eugenics, and no one was willing to contradict it. It ultimately ends because state legislatures passed laws preventing discrimination against those with disabilities. And that was the main way in which the eugenics laws had been used. And the Federal Americans with Disabilities Act also became incompatible with involuntary sterilization. So it is a story that starts in a bad way legislatively, ends in a good way legislatively. You know, as bad as that story is, I hate to say it, but it's the slight silver lining, a very, very slight. It could have been worse. In Nazi Germany, over 11 years, there were 400,000 involuntary sterilizations. They, of course, do not have American federalism. There were no state courts to stop these things. There were no state legislatures. There was no splitting the atom of sovereignty as we have in this country. So happily, it slowed things down in this country. Nazi Germany, if the national government led by Hitler wants to do something, everybody did it. And that's why you could have. And by the way, where did the Germans get the idea for eugenics? It's us. In fact, at the Nuremberg trials, their defense, when they were prosecuted for some of the eugenics what they did is under eugenics, under the banner of eugenics, is they said, "How can you do this to us? You're the ones that have Buck versus Bell." We should be ashamed of that.
Well, based on these and other stories, you really make a call to state court judges and state Supreme Court justices to, like the Ohio Supreme Court, to really focus and prioritize state constitutional questions. Citing Judge Sutton in a number of cases, a majority of justices on our court have definitely taken up that call.
What's not to like about that?
Well, I'll tell you. I have been a pretty vocal dissenter from those
Judy,
decisions.
I thought we were friends.
Most of the time. And so, and not because I don't think that we have independent authority. Absolutely, we have that. I don't feel limited in any way by the federal Constitution. I know I have independent power under the Ohio Constitution, but what I have dissented over is this idea that you just, after 150 years of saying our Constitution is the same as the US Constitution, you kind of do a right turn and say, okay, but now it's going to be different.
Yeah.
So how do you defend your, you really were the impetus for kind of this right turn?
Well, I'm certainly not going to disagree with anybody citing anything I write, of course, but I quite agree with you. And we have a real chicken-egg problem. The law schools do not teach state con law. There are 200 law schools in the country. 20 of them teach it. 2 of the 20 teach it only because I teach it there. So we're down to 18. So we only have 18. If they don't teach it, people aren't going to make the arguments. The lawyers are not pushing the arguments, which is just astonishing to me. Just to make sure everybody understands this, if you don't like a state or local law, American federalism gives you 2 shots at invalidating it. You can try to invalidate it under the federal Constitution, or you can try to invalidate it under the counterpart state Constitution guarantee. Now, this whole problem of mine has confirmed to me that American basketball players are much smarter than American lawyers. Because in American basketball, no one has ever been awarded a 2-shot foul and not taken the second shot. Every day of the week, American lawyers are saying, we don't need to take the second shot. So why is, we should be ashamed by that. American basketball players are smart, but they shouldn't be smarter than American lawyers. So the lawyers have to do a better job. And Judy is right. If a state court is going to chart a different path from the US Supreme Court, it has to explain why. But this seems like it should be easy. If there's one thing we Ohioans all have, it's pride in our history, our culture. We should have pride in our Constitution. And so that should not be hard for lawyers or state court judges. So sometimes the language of the state guarantee is different. Sometimes the history is different. Think of it this way. We would never think what the Michigan Supreme Court says about the Michigan Constitution would influence what we say about the Ohio Constitution. It's the same thing going on. Why is what the US Supreme Court saying about the US Constitution dictates the right word, dictate what we do with the state constitution? So I quite agree we need a little more briefing on this, a little more studying of the history, a little more teaching of it, and that the opinions ought to recognize good explanations for taking a different path.
Have you seen a response to your book? Law school deans signing you up?
Well, law school deans do not like offering new courses, has been my experience. But I tell them, every law school in the country teaches a class called Constitutional Law. That's what it says in the course offering. Of course, that's a lie. They're teaching half the story. They're only telling you about the federal Constitution and not the state Constitution. So what I say to them is at least start introducing the state court rulings in those classes. And no one has explained why this is wrong. So maybe that's the closest I can get to a response. I haven't had an appearance where I thought, I wish I'd thought of that. Yeah. So maybe we'll make some progress. Well, I think the reason we will make progress is we have a U.S. Supreme Court that may not be innovating as many rights. And if they create gaps, particularly if they create gaps in areas that Americans care deeply about, there is no other choice. Once they've ruled, they've ruled. You really just have one shot left, and that second shot is state constitution, state courts. So that, I suppose, for many people, that won't be a happy development, so I don't mean to be urging it, but it could happen. And that seems like it's going to make more salient state constitutions and state courts.
I want to tell the audience that in just a few minutes, we're going to move to questions from the audience. Don't be shy. I know the Columbus Metropolitan Club encourages you to get up and ask a question. The microphone is just over here. So I'm going to ask Jeff another question that maybe takes us just off a little bit in a slightly different direction, and that is to talk about kind of not only why you wrote the book, but how you wrote the book. I've heard, Jeff and I have spoken together a number of times about appellate writing, about opinion writing, and I think you have a unique way of approaching writing. And I know you are he really is just a brilliant writer. And so I think they might be interested in how you get to the final product.
Well, that's really kind of you, Judy. Thank you. And I love reading your opinions as well, so thank you. Mutual admiration on that.
Except I don't follow the Ohio Constitution.
Hey, you're young. You're young. There's time. There's time. Listen, I'm rooting for you every day of the week. I'll tell you what I really think about writing, and I think you do the same thing. 'Cause I think we have a bit of a problem in American civics. This was really one of Justice O'Connor's missions. That I think we Americans are inclined to think that what is good, what we like and what we prize, must be protected by some constitution, whether it's the federal or the state. And one reason I keep writing is I keep trying to find ways to think about a way to explain that that's really not accurate. Just because something's a bad idea doesn't mean some constitution protects it. And in fact, the rights, the liberties we care the most about, I often think we're going to do the best job protecting them through legislation. I guess a way I'd illustrate that point is if I could only have one, if I could only have the 1964 Civil Rights Act or Brown, I prefer both, and happily I have both. But if someone said, Jeff, no, in my hypothetical world, you only get one, I would take the 64 Civil Rights Act, because think of how wonderful that is. That's a law which took a long time to get enacted, probably benefited from Brown in getting enacted, but it's a law that creates a culture and reveals a culture where a majority is looking after the rights of the minority, the rights of dissenters, and so forth. That's the culture we really want. And legislatively enacted laws are really going to be proof we have tolerance. So one thing I'm just constantly trying to do in writing is explain, we can't just think of constitutions and constitutional rights as that everything good is protected by constitutions. That's just not the way it works. And I think we as a people sometimes could do a little better job trying to take care of these problems at home, whether they're in our community, our city, our state, before we nationalize. And I'll put it in an even more provocative way. When is it that the people of Ohio have a right to go beyond fixing their own problems? I mean, if we fix our problems, why can't we trust other states to see why it worked out so well and then adopt our excellent approaches? But sometimes we can be busybodies about this stuff, and we're like, hey, this is great in Ohio, and let's get Arkansas to do it. And it's great when you get Arkansas to do it, because we really believe in this, the Ohio way, we'll call it. But then we're really bummed out when Arkansas returns the favor. And they want to tell us to do something that Arkansans really care about. So I would just urge us to focus a little more on really fixing our problems at home before we race to the winner-take-all fights, because that is not helping us. And I personally think it's increasing polarization rather than diminishing it.
I see a number of people lined up to ask questions, so we'll turn to that now. It's the Columbus Metropolitan Club's tradition to take audience questions. Please state your name and ask your question. Now, in fairness to all, we'd like to get to as many questions as we can. Please avoid editorial comments. Remember that a question actually ends with a question mark. So let's get started. First question, please.
I'm Carol McGuire, and I'd like to thank both of you for a very interesting and compelling conversation. Earlier this week, the current resident of the White House announced that he was going to issue an executive order regarding the 14th Amendment guaranteeing birthright in this country. As I recall, that came out of Dred Scott, 200 years ago. I don't know how many that it's been, but a long, long time. Could you share what your thinking is with regard to presidents being able to issue executive orders that impact amendments?
Yeah.
That sounds like a great question for a federal judge.
Yeah. So judges are not supposed to opine on things that may come to them in court, but over time they become very good at looking like they are opining, but actually not opining. And let me see if I can dance around it. So, lawyers are very good at interpreting language. That's the way it goes. And, the argument against this position is that what the 14th Amendment meant at the time it was ratified is fixed, it can't change, and there's plenty of language in the 14th Amendment that would suggest the questioner's right. That would seem an odd thing for a president to do. But apparently there's some memos that have said, well, there's some explanations for not doing this. So I have one very confident prediction. If he does it, there might be a lawsuit. And we'll see how it plays out. And because the stakes of the lawsuit would have very immediate consequences. You'd have very quick rulings, kind of a temporary restraining order, preliminary injunction rulings. So you'd hear very quickly from some courts, and then it would gradually work its way through the whole system. But it'd be a fun one to watch, and it hasn't been one that's been litigated in a while, so judges kind of like that when we get to start talking about what really happened in 1868 and why. So we'll see. Stay tuned. Is this going to be a faith-based question?
I'm Richard Burnett, citizen.
Citizen.
I'm thankful for this panel. And last summer I read a book that might be helpful for us all, and it's called Just a Journalist by Linda Greenhouse, who covered the U.S. Supreme Court for many years for the New York Times. I'm wondering what the judges think about the journalists, what the impact of the press is on the, should we say, overborne coverage of the Washington scene and the under-focus, according to Judge Sutton, of the state scene. The journalists, the media, what do you have to say about their coverage?
Yeah, like, why are they not reviewing my book more? I mean, that just seems to me like such a blatant omission. But, I think I'm going to be careful about the daily journalists and covering stories, because I think it's just dangerous to assume this or that with a bias. But I'll tell you one thing that we see as judges, and it's a real virtue of appellate judging and the way the system works. So Judy sits on a court of 7. I sit in groups of 3 usually, every now and then a group of 16, but usually groups of 3. And what's really valuable is if you have 3 or 7, you get people with different perspectives, different backgrounds and different worldviews. And as a result, what comes out of that collegial process is something that, to me, I'm not going to deny the charge that maybe it still contains a bias here or there. That's a very hard thing to completely clean out. But we filter a lot of those biases out by sitting in groups of 3. And I've often thought it would be wonderful for editorial writers. So I'm focused on editorial writers. Let me focus on the 2 main newspapers, the Wall Street Journal and the New York Times. Think of how different those editorials would read if on every editorial they had to do what we have to do, which is get an agreement. So if it's the Wall Street Journal, they had to have a progressive working on the editorial and taking, and you had to account for that perspective in what you wrote. And then vice versa, the New York Times having a conservative, you had to get their approval. You had to find common ground, because we do this every day. I mean, frankly, really frustrating. But it's actually very helpful in getting rid of what I think we human beings all have some biases. And so I often wonder if that wouldn't be helpful. I doubt it's going to work, and worst of all, I don't think you'd make any money doing it. Now, I will say I would subscribe, so 1 subscriber right there.
Well, and I agree too, and I think one thing that it's such a benefit to be an appellate judge, because number one, we can take as long as we want, basically, to decide a question, and we can explain it in a document that's as long as we want. And so you help avoid some of those misinterpretations by interpreting at length. So we don't speak from the bench. Our voice is really only through our opinions, and either have a majority or I don't, but I'm always free to express my own opinion.
Yeah.
Next
Hi,
question.
I'm Kevin Bragg. I'm an attorney with Shoemaker, Loop & Kendrick. And whenever you talk about the distribution of power between the federal government and the state government, the first thing that pops to mind for me is the Supremacy Clause. And so my question is does your book, or do you have any thoughts on how the Supremacy Clause, has played a role in the sort of the growth of the dominance of people looking at the federal Constitution as opposed to a state constitution? And the second part of my question would be, just hypothetically speaking, would there be any point in thinking about, or could you even do it, amending the U.S. Constitution so that the Supremacy Clause was maybe not quite as supreme, maybe where it was that the U.S. Constitution is the supreme law of the land over the state constitutions, but if you're talking about a federal statute that's been enacted, then the state constitution could be supreme to the federal system, and would that it would probably change the way certainly lawyers behaved and
Yeah.
and the way society worked. Don't mean to put you on the spot, but
Yeah,
just
no.
curious.
This is a great question. Just to be clear for the lawyers and non-lawyers. So the Supremacy Clause is in the U.S. Constitution, and it means that if the U.S. Supreme Court has issued a decision about the meaning of the U.S. Constitution, everybody has to follow it. State court judges, state legislatures, Congress, everybody. But what it doesn't mean, the Supremacy Clause has nothing to say about the meaning of the state constitution. The Ohio Supreme Court is able to construe that to go as much above the U.S. Constitution or as much below. They have authority in both directions. The Supremacy Clause just does not speak to that. So given that, I'm not really too concerned about the Supremacy Clause. I would agree, though, with the questioner. If I could make one amendment to the U.S. Constitution, it would be that it's too hard to amend. So I would have an amendment, it requires 3/4 of the states. That basically means you can't amend anything that's even remotely controversial. And that is what has put so much pressure on the U.S. Supreme Court, arguably, to amend by interpretation, or arguably to update by interpretation to account for new circumstances. Well, as we've watched the last several years, that pressure is really consequential and problematic. So I prefer to see a U.S. Constitution that could be amended with a 2/3 of the states vote, which I think would take pressure off the U.S. Supreme Court and allow us to use the amendment process the way it was meant to be used.
My observation from that question was that it was a lawyer asking two appellate judges a hypothetical question, which is a dream. Which is a dream of many lawyers.
Yeah, no,
Yeah.
I missed that, Judy. That is what he was doing. You're right.
Yes.
He was smiling. Yeah.
Yeah. Next question. Give us your name, please.
I'm John Lowe. Help me to understand the claims about the originalist interpretations of the Constitution. How is it that the preamble to the Second Amendment seems to be ignored as far as the right to bear arms? It seems to be pretty clear that it's to maintain a well-regulated militia, and as far as I can tell, that seems to be ignored. Same with Citizens United. Free speech and money seem to get equated, and I've never seen that before. How is that an original interpretation of the Constitution?
Yeah. So the Second Amendment, I'm very good at dancing around these things. So you're referring to the Heller case, and I can give you the two sides of it. The Justice Scalia side, he wrote for the majority, and he made the point that a precatory clause, a clause before you announce what the rule is, doesn't necessarily limit what follows. That's his point. Or if you want to use the words preamble, we wouldn't think the preamble to the Constitution limits everything that follows. So that's the Scalia view. And the Justice Stevens view, he wrote the lead dissent, was the opposite, that preamble, that precatory clause really does inform what follows, and that the right to bear arms was a right that was related solely to the militia. Now, don't think you can get away with asking a question about the U.S. Constitution without me talking about state constitutions. Guess what the key move in Justice Scalia's guess what they were all fighting about? Justice Stevens and Justice Scalia, they were all fighting about history, the 18th century, and they were all fighting about what the state constitution's right to bear arms meant. Most of the state constitutions do not have this preamble. And so to Justice Stevens, that showed, aha, difference in language, difference in meaning. Justice Scalia said, well, 40 of the state constitutions have an individual right to bear arms. That shows the federal right. So anyway, it's a hard debate, I would say. And, but both, all 9 justices in that case were having an originalist debate for what it's worth. And it just was a close debate, as shown by it being 5-4.
Do we have other questions? Yes, please state your name.
Susan Kaler. Since 2014, I've been doing some volunteer lobbying of Ohio State legislators for the Convention of States project. So the topic that we advocate for is a Convention of States. And my question is, your comments were in your book is about the topic of federalism, if I understand it properly. And my question is, do you think that an Article 5 convention could facilitate, not take the place of what you advocate, but facilitate the shift of power back to states by taking it away from the federal government in the form of a constitution or a convention that might take place once. It might take place every 4 years. It might take place every 20 years. But basically a convention where delegates from all 50 states could come together to talk about some of the recent court findings. And that's my question.
No, I love it. Just to put everybody in the same place, there's only been one constitutional convention at the federal level. That's the fabled 1787 one. They've not had one since. At the state level, there's been over 300 conventions at the state level. Interestingly, the state conventions basically stopped happening in the 1970s. I think the last one might have been the early 1980s. And I'm fearful that what that reveals is why it really would be difficult to have another national constitutional convention. The reason we haven't had state conventions in a while is we live in a world where we have so many single-issue voters and single-issue interest groups, and those are very difficult for creating compromise, and that is what is necessary at a convention. It's exactly what happened at the Philadelphia Convention. I mean, the document is just one compromise after another. The state conventions have the same thing. We live in a world where we're not able to compromise. So I personally love the idea of a convention. I can't think of anything more exciting than having one, number one, and number two, being invited to it. I'm going to say, I've written a book about this. I ought to be there. And so I would love it. I feel like my ship had come in if we did it. But I'm just very worried that we're in a time right now where compromise, listening to people is not happening. And so that makes me a little nervous.
Okay. We have time for one more quick question.
Hi, my name is Denise Franz King from Dublin, Ohio, and would you comment please on gerrymandering and what its relationship is to the divisiveness that seems to be rending our nation today?
I think that question is a gift. So people care deeply about extreme partisan gerrymandering as well as they should. It's very disfiguring when it comes to electing people and disfiguring to democracy. So far, the U.S. Supreme Court has seemed unwilling to nationalize a right against it. In a case called Gill versus Whitford, they punted last term. It seems likely they will continue to punt. It's hard to say. But that doesn't mean states can't do something. So the Pennsylvania Supreme Court last March used its state constitution, aren't you surprised to hear me emphasizing this? Used its state constitution to invalidate a redistricting plan that was very problematic, according to that state court. Here in Ohio, as I think we all know, we used the referendum process and compromise, by the way, to help fix things in this state. So when the U.S. Supreme Court says no, it doesn't mean they're the only answer to the who decides question. There may be other answers. It could be a state legislature, and it could be a state court. So, you know, I can understand why someone would be nervous that the U.S. Supreme Court would fix this problem, but I would not be nervous about the possibility that state courts or state legislatures could fix it.
And please thank our speakers, Judge Jeff Sutton, Justice Judy French, and thanks to all of you for being here. We hope to see you next week.